Hi, and welcome to FinTrail's FinCrime Spotlight. My name is Ciara, and I'm joined today by Maya and Greg. So today we're going to focus on the topic of de-risking. It continues to be an issue across the anti-financial crime space, and as professionals in this area, we will attempt to mitigate our financial crime risk with the best intentions. But I think it's taking a step back and looking at, do we really consider what the full impact of our controls and how they affect those who need access to the financial sector? So looking back, in January 2022, the EBA published an opinion on de-risking, and it noted that there had been de-risking across entire categories of customers without due consideration of the individual customers' risk profiles, which can be warranted and, in their view, a sign of ineffective money laundering and terrorist financing risk management. To clarify regulatory expectations and to look at tackling unwarranted risks, unwarranted de-risking, the EBA in late last month issued two new sets of guidelines. So the set of guidelines that they issued is sort of broader and tackles the issue of effective management of money laundering and terrorist financing risk by financial institutions when providing access to financial services. And then the first set that they provided was the annex to these guidelines, which sets out specifically what firms should do to identify NPO, money laundering, terrorist financing risks, and help them understand how best, how they're organized and how they operate in practice. So we thought it'd be a good idea through this session today to talk about both the guidelines and the annex. So Greg, I'm going to start with you. The amendments are an important way to ensure proportionality and really sort of implement a true risk-based approach. And when this came out, you provided quite a useful summary about it on LinkedIn. Do you want to cover at a high level what the guidelines do draw out?
Sure. Hi, everyone. I'm glad to be back on Spotlight. I've been there before. So reading through the amendments, I think the statement really kind of draw my attention was the one saying that credit and financial institutions should differentiate between the risk associated with a particular category of customers and the risk associated with individual customers that belong to this category. I think this very often get missed in translation, right? We do that bulk approach of this particular sector is very high risk, and we basically avoiding that whole sector without being that granular about that. Even within some of those high risk sectors, there could be sectors or categories that could be businesses or individuals of different level of risk, or sometimes actually no risk. They might be operating there, but the way they operate actually might not generate any additional risk for financial institutions. So as you rightly pointed out, it is important to see the distinctions between the access to financial services and institutions' obligations in terms of anti-money laundering and countering terrorist financing. And that goes back to also how those institutions are able to work with customers who might have legitimate reasons to be unable to satisfy CDD requirements. So certainly in my previous roles, when onboarding customers, not everyone might live in a house. You've got people living in boats, you've got people living in caravans, you've got people living in all sorts of places. So, if you have a very stringent approach of you just expect utility bill and a particular type of identity documents, that might be restricting and blocking access of certain class of customers to financial sector. And when it comes to rejecting customers, again, the guidance just draw attention to making sure that the firms consider different options available. So, is this the way maybe they apply enhanced monitoring? Maybe if there is permitted under national law, they might apply some targeted restrictions to products and services. So not always blocking access is the best approach. And finally, if you do find yourself in that situation where for whatever reason you are refusing or terminating business relationship, there is a full audit trail of that decision. There's a justification for that decision, and any given time, should it be approached by competent authority and so on, you're able to provide that. Again, I think it goes back to what we've seen in the past as massive exits where basically the whole particular sectors were exited by financial institutions which could not really justify at the kind of client level why would those individuals or businesses be onboarded.
Great, thanks, Greg. I think then in the opinion that the EBA did in 2022, they identified for firms who were making those decisions, there were sort of key drivers on de-risking customers. I think it was looking at where the AML, terrorist financing risks exceeded the risk appetite, as well as sort of perceived legal or reputational risks. They also noted that sometimes a lack of expertise by firms in specific customer business models were also one of the drivers for de-risking. And then finally, the cost for compliance as well, of managing some of these relationships was another key area. So, and I think whilst they're all sort of valid concerns, it's important to take a step back and understand the impact of de-risking. Maya, do you want to maybe touch on and draw out what de-risking can mean for firms, for NPOs, and for individuals?
Yeah, sure. So, I mean, in simple terms, obviously, de-risking can mean anything from not having any access to financial services or no access to particular financial services and products, or having a limited choice, which may not and probably isn't as extreme, but it does mean that you don't have the advantages of the fair competition that as a customer you're supposed to have. And it can also mean you've got a more limited range of banks who will offer you services and products, so it's often more expensive, you get a worse customer experience, etc. And there's nothing you can do about it because other people have de-risked you and you don't have the alternatives. And it doesn't apply uniformly. And the EBA guidelines note that de-risking has different impacts on different types of customers. So non-profits is the category which everyone immediately thinks of, I think, but correspondent banking is the other one that comes up time and again, because it is particularly high risk, because the costs of compliance are huge, because you need people who really understand the correspondent banking model to manage it properly. So all the reasons you mentioned, Ciara. So there's been, I don't have the figures to hand, but a huge reduction in the number of correspondent banking relations, particularly with banks in high-risk countries. And that then really affects the ability for those banks to send and receive international payments. And that can affect countries as a whole or entire regions. Somalia is the obvious example that was nearly entirely cut off from the international banking system because it had been de-risked by virtually every dollar provider, GBP provider. At one point, a Somali MSB in the UK actually took Barclays to court and won an injunction against them because they said, if you close our account, you are cutting Somalis off from the international financial system. They won't be able to receive remittances from abroad. It would have a devastating impact on the country's economy if you do this. So at an extreme level, that's what happens. You cut off an entire country, and obviously that forces the payments underground. They're not going to stop. It will just be cash payments. It'll be hawalas. It'll be underground payments that can't be tracked and which then create their own financial crime risks. So for correspondent banking, that's the kind of impact it can have. Obviously, with NPOs, if they cannot open bank accounts or cannot access certain services, that's going to impact their ability to deliver projects and aid, particularly in high-risk countries where it's really needed, if they're not able to send the funds to those countries and to those projects. So it can result in a lack of aid reaching some of the most vulnerable people. For payment institutions and EMIs, that obviously can limit their ability to, it can cause business disruptions. And in an extreme case, if they can't get access to the financial services they need, it can lead to closing their business or not being able to expand it or innovate or offer the kinds of new products and services that they would like to, because if they do that, then their banking partners won't work with them anymore. And actually, as a sidebar, the EBA notes in this report that respondents to the call for input from EMIs and payment institutions were actually suggesting they were being not so much de-risked by their banking partners, but basically offboarded because they were direct competition. There was this grey line where the EMIs were saying, we don't think it is because we pose a money laundering or terrorist financing risk. We think it's because it's the competition. And that's why they don't want to enable us to conduct our business. So de-risking can be used as an excuse. And then, so those are all of the entities. And then finally on individuals, obviously individuals who may be legitimate customers, but they can become financially excluded because they are deemed to pose a risk. So for certain nationalities, for instance, and that obviously contradicts regulations around consumer protection and access to financial services. And it can have huge impacts on people, particularly as everything becomes more digitized. If you don't have a bank account and you can't make digital payments, that can cut you off from being able to buy certain goods and products and to properly engage in modern economic and social life. And various consumer associations have highlighted this risk and said it has an impact, again, particularly on the most vulnerable people, who are the ones most likely to be unable to provide the right documentation, to meet the KYC requirements, etc. So that can have a massive impact on their daily life, and in some cases can increase the risk of them being exploited. They have to find, using unlicensed loan sharks, for instance, because they can't access normal consumer credit. Someone else saying that they'll make transactions for them, but they'll take fees, so they are financially at a loss because they can't open their own bank account. And it also feeds into issues sometimes of discrimination as well. If you are refusing to service customers of a certain nationality, for instance, is that actually legal discrimination? And depending on which country this is in, etc., it may or may not be, but it's certainly a very controversial and ultimately harmful issue.
Yeah, thanks, Maya. And I think there's some great initiatives, though, that does also happen across the financial services sector. I know we've previously highlighted some of the work done by HSBC, Survivors Bank, and by Monies and Proxy Address to help support some of those that are more vulnerable. But I think it is worth understanding the impacts it can have across in an individual level and also at a sort of an entity level for when firms are making those decisions. I think I'd looked at FATF's definition of de-risking while sort of prepping for this, and they talk about financial institutions terminating or restricting business relationships with clients to avoid rather than manage the risk in line with FATF's risk-based approach. And I think the phrase sort of avoid rather than manage is a really key one for me. And the EBA guidelines, I think, Greg, they call out some practical ways for firms to manage associated risk. For example, looking at targeted and proportionate limitation of access to services. Do you want to maybe talk through, Greg, what sort of some of the guidelines are around helping firms manage this risk whilst not excluding certain people or sectors from services?
Sure, yeah, they definitely bring attention of credit financial institutions that the policies and procedures should, where permitted by national law, include options and criteria on adjusting the features of products and services offered to give customer on individual and risk-based basis. And that goes back to sometimes forgotten, I think, Directive 2014/92, which here in the UK has been transferred into the Payment Accounts Regulations 2015, which has been retained post-Brexit through the Payment Accounts Amendment EU Exit Regulation 2019. So it's still in force, which talks about, offering payment accounts with basic features. It also talks about, potentially imposing targeted restrictions on financial products and services, and obviously, and there is the whole variety of those which might reduce some of that perceived risk exposure financial institutions, whether that's, have some limits on the monthly turnover, have limits of the amount of type or number of transfers. So there are different ways where you could use those features as a financial institutions to potentially address some of those risks. But obviously that goes back to also to what extent that perceived risk exposure you've actually documented. So whether your risk assessment actually is up to date, whether you really thought through whether those risks are applicable to you and to what extent, and whether you really should or shouldn't be excluding certain customers with this or that profile, just purely on that.
Yeah, I think it's sort of very much around sort of setting up, taking an individual view to customers within risk categories, and then determining what that actual risk is, rather than just looking at the perceived risk you're seeing from an entirety perspective. So quite similarly then in the annex, it sets out, the EBA sets out some guidance for financial institutions around identifying and assessing the risks associated with NPOs, and it gives some risk factors and that firms might want to consider on a risk sensitive basis. Like, Maya, do you want to draw in this, because I think it's an important area to recognize that just because you're an NPO doesn't automatically mean you're high risk, and how do we actually move away from that and then applying a more risk-based approach to the sector?
Yep, it is useful. Obviously, the approach applies whether it's NPOs or it's MSBs or all of these categories, is that there is such a variety in terms of the organizations that fall under that umbrella. The problem obviously is, like, do firms have the resources within the compliance team to look at them individually? This is obviously why they sometimes decide it's easier just to de-risk the entire category. But where they do want to, and where they should try and keep the relationships, the annex gives some useful excuse me, some useful indicators. So for NPOs, it talks about governance. So does the NPO have legal status? And obviously in some countries that will involve oversight and monitoring by some form of regulator, like the Charities Commission in the UK. And so that covers quite a lot of aspects like annual disclosure of financial statements. They may have to prove the capabilities of managers to the satisfaction of that regulator, things like that. So can you draw comfort from some sort of oversight by an NPO regulatory body in the country in question? The operations, this is obviously a huge differential between where they're operating, what kind of services they're offering. So NPOs operating in jurisdictions associated with higher money laundering, terrorist financing risks versus those operating maybe domestically or in safer markets. The problem being, you still ideally don't want all NPOs operating in high-risk countries to be de-risked, but can you at least differentiate and work out which ones require that additional compliance oversight versus which ones have a lower risk profile? So are they operating in countries with higher AML/TF risks? Are they operating in high-risk third countries like conflict zones, etc., potentially countries subject to sanctions? And if they are they using third parties or intermediaries? And if so, do they monitor them? Is it clear who they are? Is there a clear flow of money to those parties in those high-risk countries? Funding methods is another area the annex calls out. So is the NPO's funding transparent and accountable? Going back to the point about regulation, does it publicly document its funding? Are those subject to some sort of oversight or maybe external audits? And do the funding methods typically seem to carry a higher money laundering risk? So cash donations, crypto, crowdfunding, or potentially private donors or donors from jurisdictions with higher money laundering or terrorist financing risks. So the more information that you can get on the funding, the more comfort you can potentially draw. And then due diligence essentially on the entity, particularly reputational issues, adverse media. So has the NPO been linked to extremism or terrorism or fraud? Has it ever been involved in any misconduct or criminal activities, etc.? And obviously, as with all due diligence, are you using relevant, reliable, independent sources to assess this? Are you considering reasons why it might not have a public profile and you can't see that much information on it, like if it's a new NPO? So there's some sort of quite basic, but some guidance around the kind of due diligence and issues that you should be looking at on individual entities.
Brilliant, thanks, Maya. And FinTrail and Greg specifically actually hosted a webinar last year on managing NPO risk. And I think if you want to sort of listen in and learn more about how to do that, particularly in that sort of proportionate risk-based way, I'd recommend looking that up on the FinTrail website. But I think sort of more broadly, that sort of discussion around proportionate risk-based measures is really applicable across the entire sector when it comes to de-risking. So Greg, as we look to bring maybe the conversation to a close, do you have any final thoughts on you want to leave firms with and how they can manage this perceived a higher risk exposure versus the backdrop of how you manage it against your risk appetite and the implementation of a risk-based approach?
Sure, and very much I think would like to go back what you mentioned earlier about some of those de-risking drivers around lack of expertise and the cost of compliance, how they intervene and how your lack of expertise might drive your cost of compliance because you're potentially applying too much enhanced due diligence in scenarios where it might not be required. And just go back to some of your examples, Maya, about there's a difference between charity operating domestically where there's basically a bunch of people, running a village fete once a year and collect money for local hospice. And we've seen a number of articles, right, in the papers about accounts being closed for those just because of the way the enhanced due diligence is being applied to those very small organizations and the level of organization capacity is a kind of almost on a par versus large international charitable organization operating across a number of jurisdictions. So that's got one of the components to another. And I think, as you already mentioned, is about going back to those basics about, okay, how, are you clear about what risks are you exposed to, then how you translate this into risk appetite statements, and then within those categories you do consider as a high risk, to what extent you're able to bring a level of granularity. So even within your high risk portfolio, there might be a way to differentiate a level of enhanced due diligence deployed, where some of those would maybe be driven by the amount of information you should obtain upfront to give you that confidence that this is a customer you're able to manage the risks, versus the intensity of ongoing monitoring, and having that very often, again, having the conversation with your clients might resolve some of the concerns. So again, going back to the charity example, again, from my previous life in the industry, we had one of the particular charitable organizations where, when we look at the pattern of their payments, we had some questions around those payments didn't seem to be structured in the kind of the most economically efficient way. So rather than making one large payments, which in the round would cost them less to produce, they tend to send loads of smaller payments, which cost them more in terms of the payment fees. But they explained to us that the reason that they structured that way is to give them more control over how those funds are being spent on the ground in the receiving country, because they did not have enough confidence that the people locally, if they being given more money, they're going to be spent in efficient manner. So for them, that was one of the ways to control how that funds are being spent and deployed. So, having those open conversation might, provide you good insight, and also provide you some confidence, I suppose, that some of those things are being used as a way to manage those controls. But I'm conscious of time. We could spend another hour or two discussing charities with Maya, so I'll hand over to you. Thank you.
Oh, brilliant. Well, as I said, I think you've got about an hour on that webinar that you did last year, focusing in on this discussion. So I think nonetheless, it is a very important and relevant discussion. I think the impact it can have at an individual level is quite severe. What it can do from a firm level, whether it's an NPO or a firm within financial services or other sectors, I think can be quite restrictive to business models, operations, and even competition, as you know, Maya. So I think it is an important area to spend a bit of time on. Just as a point of note, as we conclude this conversation today, so the guidelines will be translated into official EU languages, and there's a deadline for competent authorities to report whether they'll comply with them within 2 months of the publication of the translations, and then the guidelines will apply 3 months after those publications. I think an important point is that whether you're regulated or not in the EU, these guidelines are really valuable in helping you look at how you apply those risk-based approach to these sectors. So I think it is worth certainly reviewing and understanding what you may need to adapt to in your controls to be able to facilitate access for some individuals or sectors to financial services. So on that note, Maya, Greg, thanks for your time today, and thanks to everyone listening in. Cheers.